Yes.
Senator Mendoza.
Thank you. Let me just cut that in half right now, Madam Chair. Okay. First of all, thank you, Madam Chair, for allowing us to present SB 1332. I would like to begin by offering amendments as recommended on page 7 of the analysis to expand exceptions to all firearms in the loan provisions and to codify the reporting requirement that is currently in findings and declarations. An unfortunate string of tragic events involving the use of firearms resulting in death or serious injury continues to plague our nation and our state. Too many preventable incidents occur in which injury is caused by irresponsible acquisition of a firearm. This trend can be reversed by continuing to strengthen California's laws regarding firearms. SB 32 will ensure the safety of Californians by establishing reasonable requirements for the loan of a firearm and by creating a safekeeping program to store a firearm properly when a gun owner leaves their property. Specifically, this bill reduces the firearm loan period from 30 days to 10 days, but keeps other current requirements in place. It will also allow an exemption for safekeeping or storage purposes when a firearm is maintained locked and or inoperable for a period not to exceed 30 days, and will also require that the Department of Justice to modify its registration form so that both spouses and domestic partners may register as owners of a firearm. With that, Madam Chair, I would respectfully ask for your aye vote.
Thank you very much. Witnesses in support of the bill?
Amanda Wilcox on behalf of the California chapters of the Brady Campaign to Prevent Gun Violence. We like the proposal to change the loan lending period from 30 days to 10 days. The waiting period in California is 10 days. If someone needs a gun in an emergency situation, they can acquire a gun through a loan, but after 10 days, it seems reasonable to expect that they would go through the regular process with a background check and there'd be a record for the gun. So that makes sense to us to reduce that length of time, minimizing the period in which a person without the background check and no record has a gun. You know, I look at this bill through the lens of suicide prevention. I live in Nevada County, and our gun violence issue in Nevada County, similar to many rural counties, is suicide by firearm. And one of the times where we actually would like to see a loan of a gun is when there's a risk of suicide in the home and get that gun out of the home. And so this provision with storing a gun, the exception where the gun can be stored where it's locked securely, I'd like, because I've always thought, are we just removing that risk of suicide or an accidental gun death to a new environment and a new home? Though I am still concerned about stolen firearms, which is a big issue, and I'd like to see it further narrowed to the gun being in a locked container or a safe to ensure more secure storage.
Thank you.
But we are in support.
Juliette Leftwich, Law Center to Prevent Gun Violence. We actually are taking a support if amended position on this bill. We believe that the current 30-day loan period is too long, and we would love to see that reduced to 10 days. We feel, however, that the exceptions are overbroad, particularly the exception that would allow an indefinite loan period if the gun is kept in the lender's home. That could arguably apply to someone who's a renter in the property or you know, others visiting. We would love to see it just reduce the existing loan period to 10 days period. We don't feel like those exceptions are really necessary. As Amanda was mentioning, if suicide is a concern, perhaps there could be an exception narrowed that would specifically allow the loan of a firearm in instances where you know, a person is at risk of suicide, or if that's the concern, I would like to see it narrowed to that. So we would appreciate the opportunity to work with the author on possible amendments to the legislation.
Okay, thank you. Are there others in support of the bill? Are there speakers in opposition to the bill?
Madam Chairman, members of the committee, Craig DeLuz with the Firearms Policy Coalition. In part, we actually kind of like the bill because it is specifically in the area where it actually brings firearms policy, firearms law in line with California community property laws and allowing joint registration, so we don't have an issue with that. Our concern, it does have to do with the loan provisions. Currently, right now, with the 30-day period, it provides a sufficient enough window that if someone is in a position where they do feel a need to be able to have access to a firearm, and they are, in fact, going through the process of purchasing a firearm, they will duly be covered. If you limit it to 10 days specifically, then the concern that has is that there is actually no wiggle room. So if the Department of Justice, who's actually come to this body, and this body has passed legislation and supported legislation that has allowed them to extend it as far as 30 days, that individual would then not be covered. They would not have the same protection and the right to have a firearm. We believe that the exemptions that are included are too onerous. We believe that all of those right now are already covered under existing law. In terms of some of the concerns relating specifically to the issue of suicide and suicide prevention, one only need look at a community or a society like in the case of Australia, where they have all but banned firearms, but yet and still they've just experienced the highest year of suicide that they've ever had. And I point that out because although the incidence of suicide is there is no correlation. Although firearms may be the preferred method, it is not the only method, and not having access to a firearm, clearly, at least in the case of Australia, has not deterred individuals from committing suicide. Additionally, our concern is related to some of the concerns that have been brought up specifically relating to lost and stolen firearms. We're talking now about firearms that have specifically been loaned to someone who has taken a firearm safety course, passed it and received a certificate. These are individuals who know how to safely and have proven that they know how to safely handle and store a firearm. We believe for these reasons that you should oppose this measure. Thank you.
Okay. Thank you. Others in opposition? Seeing and hearing none, are there questions or comments from members of the committee, or is there a motion on the bill? The bill has been moved. Any questions or comments? If not, Senator Mendoza, would you like to close?
Madam Chair, respectfully ask for your aye vote, and thank you for your time.
So the motion is move as amended to appropriations. Please read the roll.
Hancock.
Aye.
Hancock, aye. Anderson? No. Anderson, no. Glazer? Aye. Glazer, aye. Leno? Aye. Leno, aye. Liu? Liu, aye. Monning? Aye. Monning, aye. Stone?
Okay, that bill has enough votes to get out. We'll hold the roll open for the absent members.
Thank you, Madam Chair. Thank you, members.
Thank you. Senator Anderson, I believe you're presenting for Senator Runner.
Yes.
Item 9, SB 1075. Yes.
He's got to offer some amendments.
He is.
Otherwise, this item 9.
Madam Chair, thank you very much for allowing me to present Senator Runner's bill. SB 1075 requires the California Department of Justice to include child molestation statistics in the Crime in California report prepared annually by the department. I urge an aye vote.
Okay. Did you have some authors' amendments that you were going to take?
Yes. I'm sorry. Thank you for pointing that out. We're going to go ahead and take the author's amendments, and what that simply does is it specifies where in the data tables the data will be reflected.
Thank you very much. Are there speakers in support of the bill? Seeing and hearing none, are there speakers in opposition to the bill? Seeing and hearing none, is there questions, comments, or a motion from members of the committee? Senator Glazer? Thank you. Would you like to close, Senator Anderson?
Thank you for the speed in which this committee moves.
Okay. All right. All depends on the bill. Please read the roll.
Hancock.
Aye.
Hancock, aye. Anderson. Aye. Anderson, aye. Glazer. Glazer, aye. Leno. Aye. Leno, aye. Liu. Liu, aye. Monning. Aye. Monning, aye. Stone.
6-0. We'll hold the roll open for Senator Stone. Senator Leno, item 11, SB 1134.
Thank you, Madam Chair and committee members. This bill is not new to this committee, and I want to thank Senator Anderson for joining me as a joint author on this. The issue is the crime the state perpetuates on wrongfully incarcerating innocent people. We as a legislature in a bipartisan fashion have addressed this issue in a number of ways over the years, dealing with prosecutorial misconduct, updating our laws surrounding DNA evidence, making sure that those who have been wrongfully incarcerated receive their due compensation from the state, and also updating our false testimony statute. Recognizing the great pain and hardship that the state imposes on people when they victimize innocent people by wrongfully incarcerating them, this bill deals specifically with post-conviction habeas corpus claims based on newly discovered evidence, and it would bring us in line with 43 other states that already has the standard I will describe to you. And the proposed standard makes the new evidence more consistent with existing standards for other types of constitutional violations. So if you file a habeas corpus claim with regard to ineffective assistance of counsel or due to prosecutorial misconduct or due to false evidence, we have one standard. But when it's for post-conviction, newly discovered evidence, we have a standard so high it is impossible to reach. So in order to prevail on new evidence claims under current law, an individual must undermine the prosecution's entire case, and law reads currently, point unerringly to evidence, innocence with evidence no reasonable jury could reject. So again, we're talking about someone who's been wrongfully incarcerated, possibly years and years later, new evidence comes to light, and we expect that incarcerated person to be able to retry the entire case to a degree pointing to unerringly to innocence with evidence no reasonable jury could reject. Memories have faded, evidence is witnesses are possibly no longer available. It just does not happen. So I'm going to end there. We have some witnesses who can add to what I've already said. If the opposition is here today and makes similar arguments to what they have done in the past, I would very much appreciate the opportunity to rebut it, because in my opinion, the oppositional arguments are so very, very weak. They will not stand up to light and criticism. But with that, I would like to introduce our presenters.
Thank you.
Thank you to the board here. My name's Alex Simpson. I'm the Associate Director of the California Innocence Project, and I want to thank Senator Leno for this bill. And I'm going to be very brief because I understand that everybody is looking towards lunch right now.
We have another meeting.
Then I'll make it very brief. This is a bill about innocence. It's a bill to make sure that people who are innocent have the opportunity to present new evidence like DNA that shows that they're innocent. And just to give you just one example about how difficult the standard for new evidence is right now, there's an individual named Uriah Courtney who couldn't be here today, but he actually testified a couple of times in the last couple of years before this committee. He was wrongfully convicted of a sexual assault. and served 8 years in prison after that DNA evidence showed that he had been wrongfully convicted, that it was actually a convicted sex offender who lived about a mile away from the crime and looked exactly like him. We presented this to the judge, and even with the district attorney's agreement that we had a wrongfully convicted individual, the judge said that he felt his hands were tied, and he was very frustrated that he had to rule in Mr. Courtney's favor because he believed that we hadn't met the standard. Why? Because we couldn't establish that these two individuals had never met before, that maybe they just had some chance encounter, the DNA had maybe transferred in some way that nobody could ever have proven. And so that's how high the standard is. It's an impossible standard to meet. And for that reason, I'm very thankful that this bill is before this committee.
Yes, hello, my name is Maurice Caldwell, and I would like to thank the chairman and the committee and Mark Leno for having me here today. And I would like to say I was an exoneree in 2011. In 1991, I was wrongfully convicted based on the testimony of a single mistaken witness. No other evidence ever connected me to the crime. At least 5 people told police I was not involved. And one person even named the real killer in a police interview, but I was sent to prison anyway. I lost my mother, my aunt, my grandmother, and my brother while I was in prison. I missed their funerals. I couldn't take care of my mother once she got sick. I missed out on 20 years of relationships, 20 years of family gatherings, spent 20 Christmases in the prison cell surrounded by some of the most dangerous and heartless people in our society. After 20 years, the real killer confessed and admitted I was not involved, but my attorneys told me even his confession might not be enough because the standards for new evidence was so high. So they also raised a claim that my defense attorney was ineffective. And when they presented everything to the court, the judge found my attorney was ineffective because he didn't investigate the evidence of my innocence. The judge didn't rule on my new evidence claim. So when I got out of prison, the DA and the press said I got released on a technicality. That really hurt me. 20 years I fought to prove my innocence. I turned down the DA's offer to let me go if I just admitted guilt and kept fighting instead. And when I finally proved my innocence, they ignored the evidence and said I got out on a technicality instead. I support this bill because it will help the innocent people who are still in prison. It will let courts truly consider their new evidence in a meaningful way. And I thank you.
Thank you. Could I just ask what county this occurred in?
San Francisco County.
Thank you. Okay, can happen anywhere. Okay, thank you. It's
thank y'all.
Amazing story. Thank you. Others in support of the bill?
Micah Doctoroff on behalf of the ACLU of California. We are a proud co-sponsor of the bill, and we are here in very strong support.
Jim Lindberg on behalf of the Friends Committee on Legislation of California. We're in strong support.
Lizzie Buchan with Californians United for a Responsible Budget in support.
Sarah Linder with National Association of Social Workers, California chapter, in support.
Ted Bradford, Washington State exoneree, in support.
Lucy Salcido Carter, on behalf of the Northern California Innocence Project. We're a co-sponsor of the bill, and we're in strong support.
Michelle Feldman from the National Innocence Project, in support.
Dennis Cuevas Romero on behalf of the California Attorneys for Criminal Justice, in support.
Emily Harris with the Ella Baker Center for Human Rights, in support.
Khalif Osagai on behalf of the California Public Defenders Association, in support.
Are there speakers in opposition to the bill? Seeing and hearing none. Are there any comments from members of the Senate?
I'd like to move this very thoughtful bill.
Okay.
That I'm joint authoring.
Yes. Thank you. I think this is a very good bill as well. Senator Glazer?
Thank you, Madam Chair. I'd like to thank the witness for his very powerful testimony today. And I'm sure I'm joined by many in expressing such regret for what you went through. I think this is a very thoughtful bill. I thank the Senator Leno and Anderson for bringing it to us. And if there's the opportunity to be a co-author, I would certainly welcome that opportunity.
Thank you, Senator Glazer.
Yes, I would also like to be added as a co-author. The motion is due pass to appropriations.
Thank you. So I think everyone understands what we're trying to do here is just
absolutely
more reasonable. And the insult to injury that Mr. Caldwell suffered, that because the standard for the new evidence was so ridiculously high, and I haven't even shared with you just what the new standard will be as proposed by the bill, that it would, that if compelling new evidence is discovered post-conviction, that it would have more than likely than not changed the outcome at a trial. And again, this doesn't let anyone go. It just allows for a potential new hearing and trial with judicial discretion. And if I could just real briefly, I had the pleasure of meeting Maurice Caldwell through his work at the Northern California Innocence Project. So he's not only been exonerated on certainly more than a technicality, but now that he is free and has his life back, what he's doing with it is working with the Northern California Innocence Project to make sure that legislation like this passes, that those who are exonerated are getting the services they need to be able to reenter. He's devoted his life to make sure that others don't suffer like he does.
Yes, I have.
Well, we want to really, really thank you for that. You know, I think it's part of what I alluded to with the family of the young person that died. Sometimes you can really heal from the great wrong that was done to you by the fact that you're helping other people so that it won't happen to them.
Yes, ma'am.
And thank you so much.
Yes, ma'am.
For both of you for being here and the work that you do.
Thank you, Glazer. Thank you for your comment.
Okay. Was that your close, Senator?
That was my close. I asked for your aye vote. Thank you.
Okay. The bill's been moved. Please read the roll.
Hancock?
Aye.
Hancock, aye. Anderson? Aye. Anderson, aye. Glazer? Aye. Glazer, aye. Leno?
Aye.
Leno, aye. Liu? Liu, aye. Monning?
I would also like to be added as a
Thank you.
Monning? Stone?
Okay, we'll leave the bill on call, but it has enough votes to pass. Thank you all.
Thank you very much. Y'all have a good day.
And our last bill of the day, Senator Glazer.
Thank you. Thank you so much.